Shareholders frequently enter into voting agreements to establish procedures for electing members to a corporation's board of directors. In Salamone versus Gorman, the Delaware Supreme Court untangled several contradictory provisions in a voting agreement to resolve a dispute between shareholders regarding how directors should be selected. John Gorman was the founder and majority shareholder of Westech Capital, a financial services holding company. Westech had two classes of stock, Common and Series A Preferred. In 2011, Westech issued a new series of preferred stock. Purchasers signed a voting agreement ensuring new investors would be represented on Westech's board and increasing the board to include 7 directors. The agreement also addressed director selection and removal. Under Section 1.2b, the majority of preferred stockholders would designate 1 director. Key holder designees would elect 2 more directors under Section 1.2c. Section 1.4 permitted the holders of more than 50% of the shares to designate a director to remove that director. According to Gorman, these sections provided for a per-share scheme, meaning 1 vote per share. As Westech's majority stockholder, this would entitle Gorman to remove and designate directors. However, directors Gary Salamone, Mark Dura, and Robert Halder, collectively dubbed, quote, the management group, unquote, disagreed. They asserted that the voting agreement provided for a per capita scheme, meaning 1 vote per shareholder. This interpretation prevented Gorman from removing or replacing directors without the approval of a majority of the individual preferred stock shareholders. Gorman and the management group each filed actions in the Delaware Court of Chancery. The court held that Sections 1.2b and 1.4 were per-share schemes, and that Section 1.2c was a per capita scheme. Gorman and the management group each appealed to the Delaware Supreme Court.